Welcome to Savant's live webinar. Today we are discussing the ideal estate plan for retirees. My name is Mike Sears. I'm in Savant's Rockford office, and I'm joined by Dom Perillo, who is in our Virginia office. Welcome, Dom.
Thank you for having me, Mike.
Yeah, it's great to be here with all of you. We have a special program today, estate planning just for retirees, those approaching retirement or in their retirement years. And when we put this program together, we really felt that there were a set of unique strategies and opportunities and pitfalls, things to watch out for individuals within this demographic. So if you think of estate planning, many times people will put together their estate plans for the first time when they have young children, when children are born. They're thinking about guardians for minor children. They're thinking about trusts, sometimes a pooled trust for those children to delay distribution, make sure their education, et cetera, is paid for, and delay distribution to a little bit later date. Often funded, primarily assets are just life insurance, usually at that point in time, life insurance and debt. But as people go through life, things change. The family situation changes and assets change. They move towards more defined contribution type arrangements that have inherent income tax liabilities and concerns that need to be addressed. Asset protection issues change, et cetera. And so, well, we really felt that this is an opportunity. If you're getting at that point in time, you want to be thinking about your estate plan and some of the ideas that we're going to give you today. Hopefully you're going to find very beneficial, at that point in time in that demographic. So the agenda for today, as is shown here, we've grouped the topics into advanced directives, beneficiary alignment and titling. That's often an area where we see a lot of things go awry. There's a great estate plan to start, a great document put in place, but over time, due to tax law changes, et cetera, or just assets changing over time, things can become very problematic. Asset protection planning becomes a bigger concern. So we want to talk about that. Again, when you have more assets to protect, you need to be a little bit more aware and acute as to some of the considerations there. We want to talk about legacy planning. Things change from taking care of minors and some of those types of concerns or young teenagers to, what does this wealth mean from my estate plan from a legacy perspective? And then choosing fiduciaries. We just thought and ethical will making would always be a good place for some discussion and involvement. So with that, we've got a lot of material to cover. So let's jump right in, and let's start where all good estate planning discussions start, and that is with advanced directives. So advanced directives, remember, these are the group of documents outside the will or trust. They fit under the umbrella of that term that include powers of attorney for property and healthcare, and living wills or declarations to physicians. These are documents where you name someone to make decisions for you if you can't make decisions for yourself. So you're still living, they're coming ahead of the estate plan, but they're really critical, especially again, as you get into these years, because it's going to become, much more likely that somebody's going to be acting on your behalf, that there could be a longer period of disability or cognitive impairment. And so they really take on additional and heightened concern, of course, as you get approaching that demographic of retirement. So a couple of things that we wanted to highlight here. We've listed 5 under this category. Older documents tend to make those directives effective upon a physician certification, sometimes 2 physician certifications. So if you haven't looked at your document for quite some time, many attorneys have now gravitated towards making the documents effective immediately. That way, children or agents can immediately step in. They can communicate with healthcare providers, hospitalists, those up at the hospital, and it's just going to make it a lot easier. You don't have to go out, get some type of written certification to trigger the authority or the effectiveness. So you might look at that and consider, and you might not have considered them appropriate to be effective immediately, in your earlier years, but as you get closer to retirement, you might consider making them effective immediately. Also, gravitating oftentimes towards adult children now as agent, as opposed to others that you may have named a few years ago. And one of the other recommendations we have is often if you have children that are in their 20s or more, in those adult years, and they're not married yet, and they maybe haven't gotten to their estate plan, it's often good to have powers of attorney for mom and dad to be named as agents for those children. So if there's a accident, you can step in, again, be at the hospital, accessing medical records and medical information. So if you have a young adult child and you're updating your estate plan, you might ask the attorney, hey, can you would it be possible for my son or daughter that's maybe of the age now where they need a POA to consider adding that as well. So a couple of other items here on this topic. We like to recommend that you confirm that you have cell numbers, older documents. Didn't tend to have contact information, but of course now we all walk around with our cell phones and we're pretty much available at all times. So if you have old powers of attorney and you're happy with the agents, even if you're not going to execute new powers of attorney into these retirement years, put a little note in there, cell numbers, contact information for the agents, and then it's right there. Provide it to your physician. It's going to be made a part of your medical records. There's federal law, the Federal Patient Self-Determination Act, that requires that to be kept confidential. And then it's just a simple process if somebody needs to contact successor agents. You might consider co-agents if you, after you name each other, again, if you have two children, you might give them authority, either of them, to act unilaterally at any point in time. That way, whoever needs to communicate with a physician or provider, if one child is there first, they can do it. Then, maybe the next day, the other child. So we're seeing more of that as well as you get into this demographic, where instead of just having it there as an emergency in succession, we're seeing some co-agents make sense as well. Again, the importance is just to think through these things a little bit. So, Dom, did you want to add any comments? Maybe I left you a couple of items to jump in: the execution in more than one state, and then just sort of the difference in the living will to the BOA healthcare.
Yeah, and thanks, Mike. Those are all really good tips for our audience. This is an area that is often overlooked in estate planning. I think people tend to gravitate towards distribution of their estate post-death with wills and trusts. And at least in our experience as investment advisors, estate planners, and financial planners, we're seeing power of attorney issues come up more and more frequently, especially with our retirees who are nearing the later stages of life. So I love all of your suggestions. I think it's critically important to have a living will declaration to supplement your power of attorney for healthcare document. A living will declaration or advance directive, depending on what state you live in, provides clear and explicit instruction to your healthcare agent on how you want your end of life decisions to be handled, because that is one of the most difficult decisions any child can make for their parent. And what it does is allow you to pre-make those decisions to remove the burden of having to make the call from the shoulder of your children and other loved ones. And of course, if you have residences in more than one state, you could always execute power of attorneys in both states, because many states have their own statutory forms, and local banks and hospitals might be more familiar with those specific state forms.
Yeah, that's great. Thanks, Tom. Yeah, and again, I guess I would recommend too, if you do execute power of attorney for healthcare in, say, Florida or Arizona, to supplement your Virginia or Illinois or Wisconsin POA, because you're spending half your time there. And again, the idea is that the institution is more easily recognizes that state's form. It's not that it wouldn't be effective, your form in that state. It's just it eases the acceptability side of it when you're using that state's form. But make sure that you don't execute a form that says that it revokes all prior forms, which is a tool that a technique that an attorney would often use, because that when you execute a new POA and you're naming new agents, you want to extinguish the old one. Well, if you're doing two POAs, one in two different states, for the time that you spent there, make sure that you don't extinguish the first state when you're intending to supplement it with a POA in the other state as well. And again, as you said, we often see situations where there are POAs but no living will. Understanding that the living will is another third document under advanced directives, often a state-specific document, that it just relieves the agent from having to make those end-of-life decisions. So you might look at your estate plan, see if you have both of those. Some people take the position, I'd rather have my agent make that decision. I don't want to have a separate document and rely on the nuances of a legalese and the English language. And, so certainly that's a very appropriate position as well. But a lot of people, I would say, probably would rather not have their agent have to do that, and they'll have the living will. So a couple of good tips, hopefully, for you there on the advanced directives. As Dom has said, really important when you're looking at the estate plan. These are things that, if you haven't looked at them for a while and you're approaching retirement, different set of circumstances and things to think about. And again, don't forget about those adult children, so you can make decisions for them if they have an accident or an illness or something like that. And you need to jump in and be able to do something short of a guardianship proceeding, which would be the alternative. And you want to stay away from that type of court proceeding, the delay and the expense there. So let's move on to beneficiary alignment and asset titling. And again, this is a something that seems like it's always an area which needs attention and is of concern to us when we're reviewing your estate plans. Our wealth transfer team here at Savant and providing advice to our advisory team members, we see frequently where assets are not titled correctly. There may be liquidity concerns because things are in a trust, and those trusts take time to get funded later on. And so we're looking for assets that are jointly owned, that and a family member can immediately take control of those assets, pay funeral bills and expenses. So we're really looking at this from a couple of different perspectives. One, are the assets titled to the trust as they're supposed to be to avoid probate, which is the design of the revocable or living trust? But two, are there other assets that are available, that aren't going to get frozen, that are going to provide liquidity? So those short-term needs. And then how do the beneficiaries line up? Because as we'll show to you here in a second, you can have a strong delay of distribution or asset protection planning for a spouse inside a revocable trust, but the beneficiary designation is like a trump card. And if you name individuals and not the trusts within the trust that you have, then the flow of those assets is not going to flow through the benefits of the trust. You're going to undermine everything that the lawyer has done. And again, we see that frequently, and it's not always just the primary beneficiary designations on assets, it's the secondary assets as well. So you want to add maybe some thoughts there, Dom, with respect
Definitely. And it's so critically important to get this right. It's a key element of any ideal estate plan. And as Mike said, we often see beneficiary designations misaligned. Maybe you took out a life insurance policy 15, 20 years ago, and at the time you only named your spouse as the primary beneficiary and no contingent. And now, you have children, possibly even grandchildren, depending on the circumstances. And ultimately what we want to do is review your beneficiary designations in light of your total estate plan, make sure everything is aligned, passing in accordance with your wishes, and then making sure there's no unintended loose assets that would be subject to probate that just increase the cost of your administration, add delays, additional heartaches. And I would say on IRA and retirement planning, especially, given the recent passage of the Secure Act, which was passed at the end of 2019, it's really important to make sure your legal documents themselves, preferably revocable living trusts, because there's a lot of benefits to having a trust in place, have flexibility and can accommodate some of these changes that were made. Because depending on the class of beneficiary, whether it be a spouse, a child, maybe a trust as the beneficiary, it'll have very important implications for how the retirement accounts, IRAs, 401ks, other tax-deferred defined contribution plans are actually paid out within the new RMD period. And we just want to make sure that the documents themselves are flexible, give your trustee a lot of discretion to help minimize overall income tax while balancing the need for asset protection for certain beneficiaries. So that this next slide just highlights some of those points. And we're going to talk in our next series of slides about different ways you could design your estate plan to protect your spouse, your children, grandchildren, other loved ones. But if you do have significant retirement balances, it's really important to speak with your advisor, your tax accountant, even your attorney, to make sure that your documents are properly oriented to accommodate these retirement monies that are a portion of your estate plan. Because again, monies that come out of the plan, whether it be an IRA, 401k, they're taxed at ordinary income rates. And if those monies are left in trust for the benefit of your beneficiaries, trust rates tend to be much, much higher, the income tax rates for a trust, than income tax rates are for individuals. So there's this balancing act that we look at and go through to balance income tax savings with asset protection. It'll make more sense on the next slide, I think, when we look at common estate plan design and how we analyze those estate plans at Savant. Mike, you want to mention a little bit about our process?
Sure. So, one of the processes that we're most proud of here at Savant is our diagramming and working with our clients on their estate plans. This is a sample diagram that we might put together, and it articulates the different assets out here. And in gray, some of the assets are titled to the trust to avoid probate. And then you can see in the design here that there's certain trusts that get created, at the first death, if there is a surviving spouse, and there'll be a funding formula that applies. Assets that are exempt from both federal and state estate tax, would be traditionally in a family trust. There might be some assets, depending on the state's estate tax law, that are subject to state estate tax, but not federal estate tax. That would be, more of a blended trust. And then red is always subject to estate tax. But you can see in this diagram that we have not only a layer of protection that benefits a surviving spouse in an asset protection standpoint, but then we have trusts drawn up here for the children if something happens to both spouses, or if it's a single person at that person's passing, we go directly to child or descendants trust. And the problem comes in with these beneficiary designations, because as I said, they trump the trust. The only way to get them flowing through is to actually have the beneficiary become the trust. So the question is, do you name the spouse as primary beneficiary and obtain the benefit of a spousal rollover, continued tax deferment? Then who is the secondary beneficiary? Is it going to be, the children's trusts down below, or is it the children outright? Okay, so I'm drawing here a little bit. The problem with the children outright or heirs, if there's not children involved, is that it's unrestricted, right? It's not subject to any restriction with respect to principal and income being retained for health, education, maintenance, and support, or to additional delay in spending, and or if there's a supplemental needs trust need for a particular child because of unique circumstances, those assets are outright. And sometimes that's even okay. Again, when you're working with those in the sort of approaching retirement or at retirement, maybe it's okay if the children receive those assets, because they're in their late 20s or early 30s, and the assets aren't of a very significant of value in relation to the entire estate. Maybe that's okay for them, okay, and you've made that determination. But what if that child predeceases, leaving very young children, okay, a 2 and a 4-year-old, the grandchildren of the person that of your child, and then what if your child predeceases and a son or a daughter-in-law were to possibly get remarried and maybe have more children, or new spouses has children. So you lose all of that asset protection. So you have to pay attention to the beneficiary designations over here and align them with your goals. And again, there are income tax implications. You can run those assets through the trust, both the trusts, either to the spouse outright or to the spouse's trust, which again is an asset protection technique for the surviving spouse, or you can run it, to the children directly or to the children's trust, as is shown here. Very different results, different income tax consequences, but one that I think more often than not, or too often, is not aligned correctly. So client does a estate plan, 5 or 10 years prior to retirement, eases into retirement, does a rollover to an IRA of a 401k, and doesn't think through the estate plan, and we don't get those beneficiary designations set up correctly. And there's also the opportunity, if you set them up correctly, to be able to pull levers and use what's called a disclaimer, which can be a nice tool. Or maybe you name the spouse as primary, but a disclaimer by virtue of a secondary beneficiary to the spouse's trust or to the children's trust. And the way a disclaimer works, it's kind of like a lever on a train track. The surviving spouse has the ability to pull that lever and redirect and treat those assets as if they predeceased. So we really want to be looking, at those beneficiary designations, looking at the estate plan. And then, and Dom, you can, I'll let you jump in here on this and comment a little bit. The problem you might say is, well, let's run those beneficiaries. Let's go spouse primary, trust secondary, and I'll let that estate plan do what it needs to do. But if the estate plan was executed, if it's a little bit older plan, it may not have the provisions that it needs to defer the tax as allowed under the tax code for the 10 years that the Secure Act allows. It may actually smash the income tax within 5 years and cause a significant amount of additional tax if it doesn't have some special provision. So Dom, without going into too much confusing detail, maybe you could just comment on those types of paragraphs and sequencing, which we would normally look for to have inside that revocable trust.
Sure thing. And I'm just thinking to myself, I deal with these topics every day, right? And I'm tracking, but our listeners' heads might be spinning hearing about all of the different combinations of beneficiary designations you can put together, trusts versus individuals, grandchildren, asset protection. And that's okay. That's to be expected. This is a very complicated area. And the big thing is, with these changes that came with the Secure Act, the planning has totally shifted as far as techniques go and drafting language that's actually in your estate plan documents. So if it's been, I would say, more than a couple of years since you've looked at things, we're definitely going to want to review your documents. Of course, you can always reach out to your estate planning attorney for that as well, to make sure that the language has evolved with the changes in the law to avoid unintended windfalls being distributed to beneficiaries given the new distribution rules and unintended tax consequences. We really want to be mindful of those items. And then, Mike, you alluded in the diagram about different designs, right, that you can employ for different beneficiaries, be it a spouse or children or grandchildren, other descendants from an asset protection standpoint. So we wanted to take time out in today's program to really walk through the different approaches. And going back to our theme of the ideal estate plan for retirees, right now, most of you have accumulated enough wealth to sustain yourself in retirement. You've gotten past that stage of just making sure that there's enough protection through life insurance policies, to cover the mortgage for your spouse if you were to pass away prematurely. Make sure there's resources there for your children to get through adulthood, right? And what we find is that as our clients near retirement or enter retirement, the planning tends to shift from protecting the family from an unexpected death to really making sure that the spouse is protected if one of the clients or spouses passes away. And there's a spectrum of complexity in different approaches, and we wanted to walk our audience and listeners through the different approaches, just so you can be mindful of how you might approach this in your own estate plan. So again, we're focusing on the spouse, right? The death of one person, and we'll get to children and grandchildren in the next standpoint if you're a single individual. But I think the easiest approach is just distributing everything under your will, your trust, outright and free of trust to your spouse. And what that means is, if you were to pass away, your spouse just receives everything in their name And then it would be up to them to retitle it to their own trust or recreate their own estate plan to handle those assets. I think the big advantage is that it's really administratively easy. There's no extended trust administration period, no tax filings that need to be done for that surviving spouse. The big negative is that now the surviving spouse is left with a choice to make, right? And depending on that spouse's age, their mental faculties, they might have difficulty actually implementing their own estate plan and reorienting and shifting assets to their own trust. So the next approach would be leaving everything in an amendable and revocable survivor's trust for the spouse's benefit. And what that means is that the spouse is still the beneficiary, but there's a structure in your document that you're creating for the spouse, a safety net that they can lean back on. And what would happen is if you were to pass away, all of your trust assets would be held in a survivor's trust for the benefit of your spouse. And they would have complete freedom to change those trust terms based on future circumstances, right? Each of the children's unique family situations, maybe there's charitable beneficiaries that might come into play, but there's a lot of flexibility there. And I think the big advantage of that compared to the outright and free of trust method is that you're creating the structure that allows the spouse to have the flexibility, but they don't really have to do anything if they don't want to. They can leave it in this trust. There's going to be default distribution terms, right, that you can pre-design with your spouse if you're, working jointly on your plan, which tends to be the case for married couples. And again, no tax filings that need to be done ongoing for that spouse. Everything is includable in the spouse's estate. So another approach, just a little bit more complicated on the spectrum. And then Mike, do you have some commentary on marital Q-tip trusts and credit shelter trusts, our third and fourth item?
Sure. Thanks, Tom. And these are the more restrictive approaches. So if again, depending on the circumstances, blended family, or even just asset protection planning, for the benefit of the surviving spouse. And these are more specialized types of trust. And again, the older documents that you would tend to have drafted probably 10 years or before we are today, they would almost always create family trusts or credit shelter trusts for the benefit of the survivor. And there was a reason, because the estate tax credit, the federal credit, was so much lower than it is today, and it was not portable from one spouse to another. So if you have a document, I would say that's 10 years of age or older, and you're in this situation with a spouse, you want to look at those formulas and look at that structure, because they could easily be out of date, based on the changes in the tax law. But then you're going to be looking at, should these assets go inside some type of trust so that the survivor can use those assets, either the income under the marital trust or a Q-tip trust, which is a specialized type of trust that provides income, and then the assets get taxed to the survivor, or maybe a more traditional approach, which is a credit shelter trust. Again, giving the surviving spouse lots of flexibility, but making sure those assets don't end up in a new marital estate or being subject to the claims of creditors of the surviving spouse. So there are a number of reasons that family trusts or Q-tip trusts or marital trusts can be utilized, for asset protection planning as to a surviving spouse situation. Again, remember, you're getting close to retirement. You're thinking about your estate plan. The two of you are together if you're married or as a couple, and you're thinking about the two of you. And hopefully the plan is you'll have that ideal estate plan, being of sound mind and body. We spent it all, and you survived together to 90 some years of age and passed away holding hands. But there's always the possibility of a long overlife. And so you need to plan for that. And again, on the earlier point, you may be using some assets, beneficiaries, like you might have an IRA that's directly to a spouse. You might have life insurance directly to a spouse, unrestricted and in category number one. You might have a joint account for liquidity and things like that. But then other assets drop down into one of these trusts that you see here in this diagram, whether it be a marital trust or a family trust or a Q-tip trust with different types of provisions. So that's the asset protection planning, that you're going to probably consider as you get into those types of retirement estate plans. But there's also, as it pertains to a surviving spouse or a significant other or an important person in your life in that regard, that's about the same age. But there's also asset protection planning with respect to the next generation, children or grandchildren or much younger heirs. So we don't want to lose sight of this. Okay. So here, what tends to happen is, again, thinking of the transition of your estate plan, you probably have something in there that maybe had a delay of distribution for young people, 5 or 10 or 15 years ago. So you want to be thinking of a couple things. One, maybe with respect, depending on the assets, maybe these individuals, children, they can receive it outright now. Maybe there's not so much of a concern. Outright is simple. They can take it, put it in their own trusts, protect it from, a dissolution of marriage by segregating it and keeping it separate. That's sort of the first approach. I'm just going to leave it to the heirs, give them the freedom to do what they need to do with it to protect it, and no separate tax return each year, no trust. The next, possibility is, I want them to get a little bit more settled, perhaps in marriages or life, and I'm going to keep it in trust, for them. And that's a very common approach. What I would do is look at the ages. Oftentimes, what was considered a appropriate age 10 years ago, people want to back that up a little bit. So when I first started practicing law, it was 23, 25, and 28 were the ages. And then it became, 25, 28, and 31, and 25, 30, and 35. And people are really pushing this back. And really, there's asset protection again. It's protection from creditors, failed marriages, financial maturity. So do you have the right ages set? I like the fractions. It allows people to get used to it over time. I tend to not be a big fan of perpetual trusts for the children, or heirs for their entire life. There's a lot of complexity there, separate tax return, even when the child is their own trustee. I think that there's at least some back and forth consideration there that you need to think about whether it's worth it or not. And then you're gonna, if you're gonna be looking at, whether or not there's maybe an appropriate need to do what's called generation skipping. Okay. And that's where you want to keep the assets in trust, restrict the children's assets so they don't become part of the children's taxable estates. Now, we're at an all-time high for exemption from a federal estate tax at $12,060,000 per person. So you can leave significant assets probably to the next generation without incurring, in all likelihood, estate tax for them. But a couple of things. One, you never know when the credit's going to come down and the political winds in Congress is going to change their mind, go back to the $1 million or $2 million exemption that existed not that long ago. But then also, does it just make sense, just as an asset protection tool, and then to make sure that they're going to keep it protected from creditors or failed marriages and things like that. So when it comes to those of you that are thinking about your estate plan again, at this generational level and this demographic, you're going to be thinking about distribution standards, generation skipping, outright versus in trust, who's the trustee, and some of those considerations to really dial that estate plan in. Don't forget, again, the possibility if a child predeceases or an heir, that if it's a per stirpes distribution, their young beneficiaries, maybe ages 2, 4, 6, are going to step up and receive mom or dad's assets. And again, you want to clamp usually down, make sure you have a protection for them, probably the same type of protection that you would have had for their parent when they were young, in 15 or 20 years prior. So anything I missed there, Dom, with respect to asset protection beyond the spouse and now looking at these other generations?
I think you covered all of the important considerations, Mike. I'll just add that your estate plan is going to be a living, breathing document. And it's important to review it, I would say, every 3 to 5 years. And certainly if there's a major life event, like the loss of a spouse, birth of a grandchild, right? A divorce in the family, because that's really going to dictate and drive how you ultimately design your plan. For I'll go back on that other slide real quick for surviving spouses. We talked about the different approaches, outright free and trust, all the way to a credit shelter trust with an ascertainable standard. So whenever you're engaging your financial advisor or your estate planning attorney, it's really important to have critical discussions and really highlight to them what your concerns are, because that'll again dictate how your plan is designed. And there's a lot of pros and cons. Are you worried about providing creditor protection for your spouse? Are you worried about there being some sort of remarriage and assets being dissipated from your bloodline heirs, right? For children and grandchildren, think about your children and what stage of life they're at now. And remember, whenever you have an ongoing trust that exists for the benefit of the beneficiary, you're going to have ongoing administrative expenses for that beneficiary, because oftentimes there are trustees involved, right? That might not be the beneficiary, especially if it's a very young person, like a young minor grandchild, and also tax filings that come along with an irrevocable trust filing. So sometimes those administrative costs and burdens can outweigh a little bit some of your asset protection concerns. And there's a lot of other methods that you could utilize, or I would say a beneficiary could utilize to protect themselves from a divorce or a creditor through the use of insurance, right? Making sure home and auto policy insurance, umbrella coverage is adequate, keeping assets separate and segregated that are inherited so they're not commingled with the marital estate. So in your discussion with your team of professionals, all of these topics are going to be covered. And I think at the end of the process, you're going to come out with a really good estate plan that really works for your family. A couple of other areas you might want to consider in your overall design. We're seeing a modern trend when we're reviewing and advising clients on their estate plan to include trust protector provisions, especially if you're going to have an ongoing trust that exists for a spouse or children and grandchildren. A trust protector is a individual that you can nominate in your document that may have the power to change trust terms after you're gone and adapt your plan to the situation in the future. God forbid, a beneficiary develops a drug or alcohol addiction, right? Things can happen. A trust protector can come in and they can change up those distribution ages a little bit to better protect that beneficiary, right? Or if there's a change in income tax or estate tax rules, right, that disadvantage your beneficiaries after you're gone, you can build in some flexibility by virtue of including a trust protector to tweak those provisions around the edges and really make your estate plan hum well for the beneficiaries. Distribution advisor, similar role. You're advising the trustee on making distributions to beneficiaries. We see this come into play a lot if you have a beneficiary who's a special needs beneficiary, or someone who needs extensive help managing resources and money. These are really good features to put in your document that I think will really provide flexibility for your beneficiaries. And then if you're operating a small business or you own rental properties, it's really important to make sure you have limited liability structures in place when appropriate through the use of LLCs or corporations. And also, again, make sure that you have proper general liability insurance coverages, right? Because part of the focus today was protecting your loved ones, that wealth that you're ultimately leaving them, but you also want to protect yourself while you're still around from potential risks that might be involved in your rental or small business activities. And then Mike, a big topic, right, after we move beyond perhaps making sure that the spouse is taken care of, making sure there's proper protections in place for grandchildren, are thinking about other legacy planning goals, such as leaving monies to charity. Do you have any strategies that you can share with our listeners on those topics?
Yeah, sure, Dom. This is great. So again, thinking of it sort of a life cycle, when you're first putting your estate plan together, it's minor children, guardians, life insurance, funding, trust. You get to the point of retirement during those retirement years, and you're thinking a little bit differently. You're thinking, more around legacy planning, sort of, what can I do with this from a, from a longer, maybe from a longer term or broader perspective. And philanthropy or charitable planning often is one of those areas to go to. And so I just thought it would be worth, bringing up. There are different types of, methods to use this. Many of you are probably using donor advised funds during lifetime, money in, money out. And really when it comes to estate planning, a legacy gift might be something significant for a field of interest or a church where it might be in the form of an endowment where it's going to be held in perpetuity, and maybe 5% or a distribution amount that's decided by the charity. That's what's going to be distributed to the operating entity of the enterprise. So it's not money in, money out for either the charity or through a donor advised fund, but it's in perpetuity. A good example of an endowment and a gift in perpetuity would be a scholarship fund. And this could be done, at a particular school. It can be done through a community foundation where, a certain dollar amount, by example, maybe it's $50,000 and it's going to generate 5%, $2,500 scholarship, every year for somebody or some individual. That would be an example of a legacy type gift. Community foundations are a great tool under the tax code. Many communities have very elaborate community foundations. These are specific creatures under the tax code where a community can consolidate assets for charity and then have fields of interest for environmental causes or performing arts or for education. And then members of the community can decide, kind of the needs of that community on an annual basis. It's a very interesting arrangement. And so you might be considering those types of things. If you have a donor advised fund, check the donor advised fund, because somebody's got to direct that post-mortem and make sure that there's a successor named or a default set of charities. And again, you could default into a scholarship program or an endowment at a charity, public charity, or of course into various funds at community foundations. Education planning, this can be for younger generations, grandchildren. It earmarks it. There are a number of ways to do it. The most common, of course, are the 529 plans. But you can set up irrevocable trusts, and they can be much more flexible. They can be used for weddings, for grandchildren, limited purposes, purchase a home, a down payment on a home, and things like that. So they give a little more flexibility than sort of the traditional education planning type of arrangements. They tend to be simple cookie cutter trusts. You could have them for all of the children or grandchildren, with a child named as trustee. They're the parent of the grandchild with some additional flexibility. Maybe it has funding of $10,000 or $15,000, something like that. Rainy day funds I've listed here. I've seen this, in 30 years of estate planning, where clients have left a small dollar amount for individuals, could again be grandkids, and it's an outright. So before you get into the children's shares, each child, a grandchild, for example, has, $1,000 or $5,000 or some small amount that's not going to cause a problem, but it's going to be there as a rainy day fund. And you might even leave a letter with it or a note. I've left this for you. I hope that you understand the importance of being a saver, having this in case the washing machine breaks or, there's the furnace at home or something. And it just gives the individual just a little bit more leverage, and it remembers the more senior generation. So, don't forget about those little rainy day funds, and then maybe a note with it. It's kind of a neat legacy item, pretty easy to do as well. I remember one instance where somebody had a housekeeper, somebody that helped them, and we had a provision to purchase an annuity. And the nice thing was, it was a dollar amount that was going to be from the trust to purchase this single premium annuity, which would provide an income stream. It could be annuitized at any point in time. And it was almost like instituting a retirement plan, or with a little bit of additional retirement for somebody that's helped you, through the years, but then not doing it in the sense that, boy, if that amount were outright, it might get squandered on something inappropriately. So the directive in the document was to purchase the annuity single premium and allow the individual to annuitize it at any point in time. And then, of course, legacy planning. You can't get around this topic without talking about family vacation property, holding it in trust. There are a number of structures where individuals will try to, reaffirm the importance of family vacation property and common use and togetherness. And so that might be something that might be appropriate. So, Dom, do you have any thoughts on any of the things that I mentioned, here at this point in the way of legacy planning?
No, I think all of the topics that you covered are good ones, and every family is going to be unique, whether it be their asset structure, right? Some of you may not be charitably inclined, right? Some of you might not have grandchildren. So the big thing to keep in mind is that your estate plan is going to be highly customized to you as the individual, you and your spouse, whomever you're working with. We just want to make sure that we cover all these important points and talk about the levers and dials that you can pull and push to make sure that you're not leaving any options on the table. I think it's important, Mike. We have another slide. We're bringing back our friend, the joint trust diagram that we had up earlier, to highlight some income tax saving strategies if you are charitably inclined. We've been talking a lot about aligning beneficiary designations properly. And what we find is that if you are charitably inclined, you might want to consider leaving a portion of your tax-deferred IRA assets to the charity in lieu of a bequest under your will or your trust. Because if you leave those assets directly to charity from the IRA, that the charity doesn't pay income tax on those assets, and you're preserving a larger portion of your after-tax estate for your spouse, your children, grandchildren. So I think it's a great way to allow you to meet your charitable goals or pledges that you made during lifetime, while saving overall estate tax overall income tax for everybody involved. So definitely think about that. Very easy to change a beneficiary designation with simple paperwork with your investment advisor or your bank, right? If your IRA is at a bank, it's a lot easier to do that versus changing the provisions of your trust or your will, which would require an amendment, more time with your attorney, more dollars being spent. So really important tool that we can utilize, and it's something that should be reviewed often as your intentions may change over time. And then I think real quick, it's important after you've come up with the ideal design of your estate plan and you're confident that you have the right structure for your spouse, your children, grandchildren, other intended heirs, right? Potential charitable bequests, to start thinking about, well, who the heck is going to be in charge of all this after I'm gone? And that's where this fiduciary concept comes into play. So the big fiduciary in estate distribution, especially if you're utilizing a revocable living trust structure, is going to be a trustee. And this is a pretty important aspect, I think, that can stall out the estate planning and document implementation process, because there's a lot of choices, right? You can name the surviving spouse's trustee, right? That tends to make sense. But then beyond that, is it going to be the children stepping in as trustees? Are they the right ages, right, to manage the trust funds properly, right? If you have concerns about your children or intended heirs' ages, maybe you look to other family members. Maybe it'd be good to look at a corporate trustee or a professional trust company to take on those duties. And there's a lot of pros and cons, right? On the next slide, you'll see that being a trustee is a very thankless job. You have a fiduciary relationship with the beneficiaries. You're providing accountings, you're marshaling assets post-death, filing income tax returns, interpreting the trust document to approve distributions. And if your loved ones that you might be thinking about naming as trustee don't have a lot of experience, they might be lost in this process. So you don't have to be a professional trustee to serve in that role. You can always look for help, right, from your attorney or financial advisor to help guide that trustee. But if you just want to remove the burden entirely from your loved ones, you could consider a corporate trustee. The disadvantage to the corporate trustee would be the additional administrative fee that corporate entity or professional trustee may charge. That's in addition to any investment-based fees that would be charged by your investment advisor. There's no right or wrong answer. It really depends on you and your family and the people that you have in mind. So as part of your discussion with your team of professionals, make sure you're fully vetting all of your options and coming up with the best structure that you can. And our last topic today goes beyond the estate drafting, right? After you've got your documents in place, asset protection's been covered, you've got your all-star team of fiduciaries who are going to be handling your affairs post-death. Then you can start thinking beyond the legal documents themselves and consider an ethical will. Mike, can you tell our audience about this concept and why and how it could be important to them for consideration?
Sure. Ethical wills is it's been around for quite some time. It's really gaining additional steam, I guess I would say, in contemporary estate planning. And what it involves is thinking beyond assets in the context of financial value. We think of, as lawyers, we do things to create trust structures. We've been talking about many of them, asset protection structures for a surviving spouse or for children or for grandchildren. Who's the fiduciary? You're thinking about the document, but you're not really thinking about what does this wealth mean, for the family? What are the life lessons and the heritage, that I want to impart to my family as part of my estate? And historically, if you look at estate planning, Dom's licensed in Virginia, in Florida, I'm licensed in Wisconsin and Illinois, and you think about the design and development of trusts and documents. Well, it's really historically been just the last 100 years that anything but the aristocracy had wealth to leave to the next generation. And what traditionally was it was family values, it was stories that were handed down, it was heritage. And that's what ethical will making is how can I infuse a little bit of that back into my estate plan? And so it means keeping future generations connected. It means teaching proper stewardship of assets and creating structures that don't have inherent conflict from one generation to another. And again, estate planning attorneys often don't. We can look at documents and look at the provisions in there, and we can see where inadvertently maybe there was a design for conflict. So one example of this might be where there's pooled beneficiaries, where the children and the grandchildren are beneficiaries at the same point in time of a multi-generational trust. And the problem is it's kind of like a cookie jar, and everybody wants to get their hands in until the cookies are gone. And so they're kind of earmarking it. And a solution to that is, well, I'm going to leave it in trust for my children. Maybe it's a generation skipping trust, and I'm going to give them the power to spray it to grandchildren or other descendants, their children, but not a common legal right. I'm not going to mix those legal rights up. And so that would be one example, where you're kind of looking towards, avoiding conflict in future generations and certain types of provisions that do that. But you can do this a number of different ways. You can leave, notes with respect to personal property items. I'm leaving this ring to this individual, and I want you to know and understand and appreciate this was my mother's ring or my grandfather's watch. It brought with him from far away, and so there's a moment, there's a lesson that goes with the asset. It's not just the financial value of the asset. So you could add, direction, personal property transfers, memorandum to your estate plan, outside documents that you can easily change as to the disposition of these effects. You can leave letters to spouses or to kids or to grandkids. You could write a book to the next generation. I've known many people that have done that, talked about where the family wealth came from, or even if it's not family wealth, it may be I have a a father-in-law who wrote a book, just the life and times of himself, very simple and straightforward, and has provided it. And it's just great fun. It's easy enough to do nowadays. Just some of the things that happened in childhood. You can add pictures very easily and compile these things. You can do videos and taped messages, with different meaning and heritage. So again, we wanted to include that in our discussion. Again, in those estate plans, as you're approaching retirement or in retirement years, you've got a lot of wealth and knowledge and information. Younger generations are really in need of that. Don't forget the opportunity to, as you get into your retirement years, sit back, think about some of the things that you've done that you want to teach, and incorporate that as well into your estate plan. So, all right, we've saved 5 minutes for some great Q&A. It's been awfully fun to focus on this type of an estate plan. And Don, maybe put up the diagram if you can, because I see some of the questions here might be a little bit easier. Let's go back to our friendly diagram there for a second. So a couple of items, and I'm glad, we'd love to have these questions, can put them in there. So there was a comment on beneficiary designations, and certainly, to be sure, all of these types of accounts, whether they're IRAs or life insurance, they're going to have a default structure. If you don't have a secondary named beneficiary, those institutions are going to have a default, and it's really important. Per stirpes, being a legal term to descend to the next generation, or per capita by representation. If you name the beneficiaries and think it through, you're going to control the direction, and that's what you want. You've got to be careful of those instances. Otherwise, POAs, naming co-agents, you can have conflict. If you name co-agents that the two kids aren't going to get together, certainly, but you could make it so they can both access information and communicate with physicians, but only one makes the decision regarding medical care. That would be one way to handle that. But you hope that that they're going to work together. But again, that's a great question. There can be conflict when you name co-agents. Same thing with co-executors and co-trustees there. Let's see.
There's a question about income taxation of trusts. And, this is an area that would probably warrant a whole discussion with your financial advisor and even your tax accountants. But, the comment or question deals with the compressed nature of the tax brackets in trusts from an income tax filing standpoint. And just briefly, I'll say that you get to the highest income tax rate in a trust, if you're dealing with an irrevocable trust, at $13,451 of income, trust income, interest, dividends. Capital gains are taxed at 20 and 15% rates, depending on how far you get up the threshold. But there's ways to manage that taxation in the trust through proper distribution planning, making sure that income is actually distributed to beneficiaries to minimize the tax exposure. There's a concept called DNI, or distributable net income. So I think the comment here is certainly well taken. Whenever you're working through your estate plan, it's important to coordinate with your accountant, the actual tax preparer as well, and your financial advisor to ensure that you're minimizing overall income tax within the trust structure that you're utilizing. I'm going to go back to our Q&A slide here.
Yeah. So I would just add to Don that there was a great comment regarding the taxation. If you trap that IRA in the trust, you're going to get those higher rates. If you flush it through to the beneficiary, you can carry that tax out. But the principle we were driving at really was, you don't want to capture, make it so that the account has to come out of a tax deferred status in 5 years. You'd like to stretch that to 10 years if you can, because you'll get 5 years of additional tax deferred growth, and then flush it through to the beneficiary. So question regarding a surviving spouse acting as trustee of a marital trust. Absolutely. That's totally acceptable. Question regarding our attorneys, and maybe we'll just conclude with this. We are not like the states that we're not licensed in. estate planning is, there's federal estate tax law, which transcends states, and many of the principles that we're talking about, of course, are design principles that transcend states. So even if we don't have an attorney that's licensed in a particular state, that really is simply a barrier if we were going to draft documents in that state. And we don't draft documents, in any state. So we do have an entity that assists our clients in some states, but we don't, we would never draft documents in other states. But again, we can help our clients make sure, be that bridge with outside legal counsel and make sure that, your documents are great. You've got two sets of eyes looking at it. All the ideas are coming together. So we really work with attorneys routinely, all over the United States. So that's all we have time for today. Thank you, Dom, for your help today. I encourage everybody to put some more questions in your surveys. There's going to be a survey that will pop up in your web browser. And if you can put questions in your survey, we'll get back to you on those as well. We appreciate the opportunity to be of service to you. We love what we do here at Savant. Our team of attorneys and trust officers and those on the wealth transfer team go out and put together that ideal estate plan. And if we can help in that regard, we would welcome the opportunity to do that. So have a great day, everybody.